I go to that property, I come in front of him, I'll never get out of jail.
So this one starts as a plea hearing on a reduced misdemeanor charge, but as the court goes through it, the backstory turns out to be more complicated than the charge itself. After the hearing, I'll also break down something interesting about how this particular Georgia statute is coded. My name is Dan. This is the Courtroom Files.
No contest as in a nolo?
Yes, Your Honor.
He's playing no.
Okay. All right.
It's being reduced to a misdemeanor, Judge.
I see. Well, let's get on the record. This is 23 SC 191961, State versus, is it pronounced Moten?
Yes.
Rodney Moten. Mr. Moten is here in court with his lawyer, Mr. Arnold, and our prosecutor, Ms. Davis, is here. Mr. Moten, I'm Judge McBurney. I don't think we've ever met. I am covering for a judge who was covering for a judge, but we are all given the same authority to take pleas in what was originally a felony case. I know you're pleading to a misdemeanor. It was originally a felony, burglary in the first degree. And it's my understanding that you're ready to go forward with that plea. Is that correct? All right. Ms. Davis is going to swear you in just a moment. Once you are sworn in, it's important that you answer all her questions truthfully and completely. It's just as important that you let me or Mr. Arnold know if you've got any questions. I need to be comfortable that you understood everything we discussed. I bet you will, but I won't know if you've got a question unless you grab your attorney's shoulder or raise your hand or something like that, okay?
Yes.
All right, make sure you speak up so the court reporter can hear you when you're answering. Ms. Davis?
Mr. Moten, please raise your right hand. Do you swear or affirm the testimony you will give in this matter before the court will be the whole truth and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Rodney Moten.
At this time, are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medicine that you normally take that you have not taken today?
I took all of my blood pressure pills, high blood pressure and high cholesterol. Took those.
That's the only medication you take?
Yes, for right now, in my when my side started hurting from my cancer, I take the medication that they gave me.
Got it, but your side's not hurting right now.
Nah, but it will once I, start sitting and doing a lot of things.
Okay.
It starts hurting, like if I walk too far or, it start hurting because my cancer is, they say it's kind of coming back. So I got to watch my numbers. So.
Got it. Well, I'm sorry to hear it's coming back. So today, so far, it's been blood pressure and cholesterol medicine.
Sir.
When you take those medicines, do they make you sleepy or woozy or confused?
No, not really.
No, you feel like you know what we're doing.
Yes, sir.
Great.
How old are you and how far have you gone in school?
57, 12.
Are you able to read, write, and understand the English language?
Yes,
Are you a United States citizen?
yes,
Do you understand that you're charged with the following offense in indictment 23 SC 191961? And we have amended the burglary in the first degree charge to that by taking. Are you aware of that?
yes,
And that would be OCGA 16-8-12A. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you had enough time to speak with your lawyer, Attorney Arnold, about all the facts and circumstances known to you in this indictment, including any potential defenses?
yes,
Do you need more time to discuss this case with your attorney?
no,
Are you satisfied with his services?
yes,
Attorney Arnold, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
yes,
Mr. Moten, do you remember being arrested on these charges?
yes,
Your Honor, the state's unaware of any outstanding warrants related to this matter. Attorney Arnold, are you aware of any outstanding warrants related to this case?
no,
Mr. Moten, has your attorney advised you of the minimum and maximum sentence for the charge to which you're pleading to today?
yes,
The maximum sentence is 12 months. Do you understand that?
yes,
Do you understand that today you're entering a negotiated plea of guilty, which means, or NOLO, which means the state will make a recommendation to the court?
yes,
Do you understand the court's not required to accept the state's recommended sentence?
yes,
Do you understand the court has the right to sentence you to the maximum possible sentence for this charge?
yes,
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading to this, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand you're waiving all of those rights?
Yes.
Do you understand that you may have only a limited right to appeal this plea conviction?
Yes.
Do you understand that you do not have the right to appeal directly from your plea, but if you believe there is some error, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today.
Yes.
Do you understand that you have only 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
How do you plead to the charges in indictment 23 SC 191961, theft by taking?
No content.
Has anyone forced you, threatened you, or promised you anything to get you to enter this plea?
No.
Is it your decision to waive these rights because you decide it's in your best interest to do so?
Yes.
Is this plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes the evidence would show that on January 4th, 2021, the officers with the Atlanta Police Department were dispatched to the incident location, which is 2125 Joseph E. Boone Boulevard, Northwest in Atlanta in Fulton County, in regards to a larceny call. Officers there met with the victim, Mr. Constantine Foca, who reported that while he was in his office, he noticed that one of his tenants, the defendant, Mr. Rodney Moten, was inside his residential unit. The victim questioned whether the defendant was inside his unit, and the defendant reported that he was waiting for a friend. The victim noticed the door to his unit was open and that several items were missing. The victim and the defendant had a tenant-landlord relationship. And I believe it was like a wallet that was missing. I did speak with the victim. He did feel like there was something else going on with Mr. Moten that day. And so he was comfortable with resolving this matter. The state is recommending 12 months to serve 6 months. The defendant spent, I believe, 176 days in total. So he is satisfied that time. The balance would be suspended. Nothing further. And Mr. Moten does not have any felony convictions.
There was an aggravated stalking arrest after this, which makes up about half of the 180 days. That case went nowhere, as far as you know?
As far as I know.
far as
It'll
you
be
know.
a different unit,
Okay.
but as far as I know.
Okay. So 12 served 6 months, balance suspended, and credit for the time he's been in.
Correct.
Understood. Okay. Are you with probation, DCS? Hi. Do you have, I know you're not pretrial services, so your view into Mr. Moten's possible criminal history is different, but do you have any indication he's ever been on felony probation? He has not. Okay, thank you. And you are Officer Finney? Great. All right, thanks for being here. Mr. Arnold.
Yes, Your Honor. My client was in his landlord relationship based on a government contract. My client had gotten a large subsidy from the government based on some disabilities. And that's one of the reasons why the victim in this matter thought something was going on with Mr. Moten. Since that time, they've had no other contact with each other. Based on this incident, Mr. Moulton lost that subsidy. And so he was, he had to struggle for a while finding housing, especially with this pending charge. That's one of the main reasons why this was such a burden on him. And so he's hoping by the resolution of this case today, he'll be able to get back on that subsidy. The court has already been made aware that he's still undergoing some serious medical issues. And he also has some additional family issues going on. So he's asking the court to follow recommendations for that reason. And as far as I know, they have had no, other than that government subsidy, they've had no further contact since this incident.
Okay. Because that was going to be my question, Mr. Moten. It sounds like you moved out of that Joseph E. Boone address.
Well, the last judge told me, don't ever go back to that property.
Okay.
Never went back over there. He said, if I go to that property, I come in front of him, I'll never get out of jail. So
Oh,
I lost everything. Then.
okay.
I lost over $5,000. He kept all my stuff. I couldn't get a hold of no cop to assist me to go get my property.
To go
So I
collect your
lost
belongings.
over 5,000, and then I lost my Section 8, and I lost my apartment, and now I can't get housing or nothing.
Where are you staying now?
With my cousin,
Is that the Irma Street address?
yes.
Okay. Are you able to stay there longer, or does your cousin want you out?
Well, you know how cousins is, when they get tired of you, they tell you you have to go. But I always been on my own. I always had my own. So
Okay.
It kind of put me, yeah.
Well, this will close the case out. Is your plan to find your own place?
Yes, sir.
Are you able, this will not be a felony conviction. It's not even really a conviction. It's a nolo plea. Are you hoping to get back into the Section 8 category?
Yeah, but yeah, he called and told him a whole bunch of lies and everything, you know what I'm saying? That wasn't his.
Yeah, in addition to the stairway, the landlord also, because it was required to him to report everything, he also made a record of it. So that's been a part of the issue of being recategorized in that category.
Okay. All right. Well, Mr. Moten, I wish you the best moving forward, especially with your health challenges. Keep seeking medical attention. I find there's a factual basis for your plea. I understand why it's a nolo plea. I'll accept it as a nolo plea. This also was something that happened 5+ years ago, so it's good to move on. I find that your plea is knowing and voluntary. Knowing means you've understood the things we discussed. Any questions about anything?
No, sir, I just need, some kind of,
Yeah, and use
Paperwork.
documentation. That's,
so I could try to get back into, even I can get back to getting back into college now.
Great.
It's all this is, yeah, I want to get back into Microsoft and the internet, you know what I'm saying? That's what I want to.
All right. Well, a lot of opportunities there. I hope you're able to do that. And you're certainly young enough to start a new chapter. And Mr. Arnold can help you get all the final paperwork that will flow from today. Mr. Moten, I am holding the indictment in your case where it says no contest and it's been reduced to the misdemeanor. Did you sign this document?
Yes.
You did. Great. That indicates your plea in the case. I'm going to sentence you, Mr. Moten, to 5 months to serve on this misdemeanor, but you'll get credit for the time that you did serve. And that's it. That'll close the case out.
Thank you.
Okay? Ms. Davis, anything else in Mr. Moten's case?
Nothing further from the state,
All right,
Judge.
don't run away quite yet. Mr. Arnold, anything else for Mr. Moten?
no, Your Honor, I'll make all the additional paperwork he was asking for, I'll make available to him once the court is signed off.
Sounds good. All right, now you can run away.
Thank y'all.
See ya.
Now you can run away indeed. Good morning once again, everybody. TCF Live. It's Monday. We're halfway through the show already. Michael Groff, 12 months with us now. Anybody who doesn't appreciate Michael Groff, something is wrong with your brain and you should seek medical attention. Michael is the best. Came to us a year ago. Immediately, I saw his talent. I'm so impressed by him. Over the last year, he has not only guest hosted this show, he's been a mainstay on Sidebar, a regular in our chat, a big supporter of this channel, and honestly has become one of my best friends. So, Michael, thank you for being who you are. Thank you for everything that you do for us, and you are very much appreciated. CMS, in the chat a little while ago, you were questioning, or just commenting rather, on the complexity and the knots that the legal system ties itself into, and you specifically cited the theft by taking thing. It's not the legal system that's tying themselves in knots there, it is the legislature. Specifically in Georgia, I looked this up. They define the different variations upon theft within their code. So it all stems from code 16-8-2. It defines theft by deception, theft by conversion, theft of services, theft by shoplifting, theft by receiving stolen property. It also has provisions in there for stolen goods being brought into the state, livestock theft, cargo theft, trade secrets theft, and porch piracy theft. So there is a lot that actually goes into how they define theft, and that's why they don't just say you stole something. The statute actually defines how the theft happened, not only that it was just a theft, and then the prosecution kind of defines their case accordingly. So that's what goes on there. Michael, thank you for gifting a membership. Very much appreciate that. So I just thought I would share. That is why things happen the way they happen in Georgia. So in the end, I think this is one of those cases where the courtroom resolution doesn't necessarily capture everything happening around it. The charge may have been reduced, but the consequences outside the courtroom sound like they're much bigger. Let me know how you see it, though, down in the comments. And before you go, do me a favor and check out one of the 2 videos that are on your screen right now. Thank you so much for watching.